Morning. Gang, I've got a quick question for you. Did any of you guys need to put in a meeting passcode for today's training?
Yes, I did.
Was it just the contract training ID, the 965 number?
No, it was 905 something. 905,099, I think.
Oh, that's
I
right.
got right in with no problem, no passcode.
Yeah, 905,099. It's if you click on the link in our training calendar, it comes up with the Zoom meeting link, and then it has the meeting ID and passcode below that.
Okay, Tammy, one more time. What's the code?
905,099.
099. Weird. Okay. All right, well, we'll have to troubleshoot that. Okay, hang it up. All right. See Joni there now. Okay, you guys. So we are, and everyone can hear me okay, right?
Yes.
Awesome.
Right.
Okay. So we're just continuing on with the second half of the listing contract today. This should go pretty quick, the second half. Just a lot more definitions and just some additional provisions for the sellers. And then the last page is just signature and delivery lines. So, but starting on page 4, getting into definitions. First up, we've got adverse fact. So an adverse fact is a 2-part definition. It's a condition or occurrence that is generally recognized by a competent licensee as doing any of the following. And this pretty much mimics the definition of a defect. So significantly and adversely affecting the value of the property, significantly reducing the structural integrity of improvements to real estate, or presenting a significant health risk to occupants of the property. And then the second part is that the adverse fact could also be information that indicates that a party to a transaction is not able to or does not intend to meet his or her obligations under a contract or agreement made concerning the transaction. So again, when you think of an adverse fact, generally you're thinking of those items that pertain particularly to like the structural integrity of the property, again, safety hazards, again, kind of in line with that definition of a defect, which we'll get into in a second here. And then in a bit, I will also differentiate between adverse fact and material adverse fact, because there is a difference. Moving on, in lines 175 to 176, we've got a definition for deadlines. So deadlines expressed as a number of days from an event are calculated by excluding the day the event occurred and by counting subsequent calendar days. So when you get that accepted offer, let's say that inspection contingency is due within 15 days from the accepted offer. So let's say we had an accepted offer today, January 31st. Day 1 would be February 1st and so forth. So that final deadline would be February 15th. So you exclude the day that the offer was accepted, and then day 1 counts is starting the next day. Sometimes you will see in offers that a deadline will be expressed in business days. So if you do see that, make sure that you are excluding weekends when you're counting out your deadlines. Defect. Defect means a condition that would have a significant adverse effect on the value of the property, that would significantly impair the health or safety of future occupants of the property, or that if not repaired, removed, or replaced would significantly shorten or adversely affect the expected normal life of the premises. So when you are negotiating those inspections, this is the definition of a defect that you will call upon. Firm. Firm means a licensed sole proprietor broker or a licensed broker business entity. So Keller Williams is your firm, and you are an agent of the firm. Fixture. A fixture is an item of property which is physically attached to or so closely associated with the land or buildings so as to be treated as part of the real estate, including, without limitation, physically attached items not easily removable without damage to the premises, items specifically adapted to the premises, and items customarily treated as fixtures, including, but not limited to. Then it goes on to give many examples of what a fixture would be. So this is just important to, if you need to refer back to this definition when you are going through your inclusions and exclusions list with a seller, reminding them that anything that is physically attached to the property is considered a fixture. So like those light fixtures, for example, garden bulbs is one of the first examples listed here. Perennials. I have had sellers who have wished to take perennial gardens with them. Those need to be specifically excluded in a listing contract. There's also a warning here about items that are rented. So if there's a water softener, for example, in the home, make sure that you're asking that question to the seller. You know, is this rented, or or is this part of the property? Do you own this? If it is a rented component, then you need to list that as an exclusion in the MLS and in the listing contract. Another item that we get a lot of confusion on are TV brackets. So the TV itself, on that TV bracket is considered personal property. You can take that TV off the bracket and take it with you. The bracket itself, though, is considered a fixture. It's affixed to the wall. If you removed it from the wall, patching and painting would need to happen. So I just, instead of having any sort of confusion about those items, for example, I always specifically list that in the inclusions and exclusions and not leave it to be a question for anybody. And likewise, when you are writing offers on properties, if you don't see TV brackets, for example, listed in, or anything really, I mean, it's better just to be specific in your offers. If there's any question about anything, just list it as an inclusion or exclusion, or ask the question of the listing agent. Any other, again, I always bring up this example, but I feel like this is one that comes up a lot. Bathroom mirrors. Sometimes there are bathroom mirrors that are actually personal property. You can pick it up off of a nail, and seller can take it with them. But it looks so closely, like aesthetically, it looks like to be a part of the room, you know, so just make sure that you are making sure that a bathroom mirror is either included or excluded. Another, again, I like to just recall examples of where there's been some contention. We had a example a couple of years ago of a bar that was in a basement that looked, I mean, it was a part of the room. I mean, it made the room, it was set up as a bar. And the seller, they went from the final walkthrough, seller took the bar with them because it was a movable cabinet on the ground. It wasn't affixed to the ground. So of course, buyer was upset. You know, that definitely needed to be something that if the seller had planned to take with them, that needed to be listed in inclusions and exclusions on the MLS.
Yeah, whoops, I'm muted. Another thing to advise your seller when you're going through this is, say they have a really nice chandelier or light fixture that's part of the family and they love it.
Oh, yeah.
The best idea is to replace it before the property goes on the market. So a buyer going through falls in love with the family heirloom light fixture, and then there's a dispute over it. So if they're going to take it out before the showings start and
Yeah.
replace it with something else.
Yeah. Yes, it's an excellent idea. Again, we're just trying to think of just getting ahead of problems and getting ahead of issues. Just assume that it could be an issue for somebody. So just get ahead of it. And again, on those final walkthroughs, you know, we get through our inspection contingencies, and that's, you know, like the biggest hurdle of a transaction. Usually the second biggest hurdle is final walkthrough and what happens at a final walkthrough. So any questions on that? Okay. Material adverse fact. So a material adverse fact versus an adverse fact. Material adverse fact means that an adverse fact that a party indicates is of such significance or that is generally recognized by a competent licensee as being of such significance to a reasonable party that it affects or would affect the party's decision to enter into a contract or agreement concerning a transaction or affects or would affect the party's decision about the terms of such a contract or agreement. So, you know, when we're discussing and going over those duties that we owe to all clients and customers, we owe the duty to disclose all adverse facts of a property to customers and clients in a transaction. If a client if you're entering into a contractual relationship with a client, we then owe them all material adverse facts. And the biggest example that I like to use with this is that train track example. So if I'm out showing a buyer a home and I'm working as a seller's agent, and there's that set of train tracks in the backyard, that would be considered a material adverse fact, and I would not need to disclose that to a customer in a transaction. If I'm acting as a buyer's agent when I'm on that showing, that same set of train tracks is definitely a material adverse fact that we would want to disclose to the buyer client and let them know this could affect resale for you. Would this be something that would prohibit you from wanting to enter into or writing an offer on this? Or would it change how you would write the offer? Would you offer less because of the set of train tracks? So that's kind of that slight difference between a material adverse fact and an adverse fact. Adverse fact, I like to think of in any issues that are going on with the components of the home itself, the property itself. Those material adverse facts are those is that information that is extraneous outside of the property itself. Joni, do you have any other good examples?
Not off the top of my head. I mean, where it really comes to light is if you see these, if you as the agent see these material adverse facts and the seller's arguing about it. Oh no, that's not a problem. That's where you have the duty to disclose those material adverse facts in writing. So it's important to understand what they are and what your responsibilities are.
Yeah. If you have any questions, obviously come to Joan or I.
Right.
Person acting on behalf of buyer. So person acting on behalf of buyer, I mean any person joined in interest with the buyer or otherwise acting on behalf of the buyer, including but not limited to buyer's immediate family, agents, employees, directors, managers, members, officers, owners, partners, incorporators, and organizers, as well as any and all corporations, partnerships, LLCs, trusts, or other entities created or controlled by, affiliated with, love these run-on sentences and these legalese, affiliated with or owned by buyer in whole or in part, whether created before or after expiration of this listing. So if you are dealing with a trust, for example, you might have a representative of the trust who is signing the paperwork. And that is that's a person acting on behalf of a seller. But there are people who can act on behalf of a buyer as well. Property, unless otherwise stated, property means all property included in the list price as described on lines 2 through 5. Protected buyer rolls right into the next provision on extension of listing. So I'll talk about those two together. So an extension of listing, when or if you come to the end of a listing agreement and or listing term and the house has not sold yet, there's a provision here that the listing term is extended for a period of 1 year after the original expiration date of the property of the listing contract, excuse me. So what that means is that any party who has seen the home during the time that we had it listed. So anyone who has seen it, anyone who has written an offer becomes what's called a protected buyer. And if any party decides to write an offer during that 1-year period after the expiration of the listing contract, and there's a successful closing, we as the firm could be owed or are owed the commission on that property or on that sale. So if that does happen, if you're ending a listing contract with a seller, home does not sell, within 3 days, we need to put together what's called a protected buyer list. And we will name all of those parties that saw the home or wrote an offer on the home, and we will deliver that to the seller. And then the seller files that letter. They either give it to their next agent if they're going to be working with another agent, or, again, keep it. And if they enter into a offer to purchase agreement with one of those named protected buyers offline, or just between the two of them, that seller still owes us a commission. So very important that that letter gets out in a timely manner. I'll just go through the provision right now. The listing term is extended for a period of 1 year as to any protected buyer. Upon receipt of a written request from a seller or a firm that has listed the property, the firm agrees to promptly deliver to seller a written list of those buyers known by the firm and its agents to whom the extension period applies. Should this listing be terminated by seller prior to the expiration of the term stated in this listing shall be extended for protected buyers on the same terms for 1 year after the listing is terminated. So, and then I can go through the examples of a protected buyer again. So, protected buyer means a buyer who personally or through any person acting on behalf of the buyer during the term of the listing delivers to the seller or its firm or its agents a written offer to purchase, views the property with the seller or negotiates directly with the seller by communicating with the seller regarding any potential terms upon which the buyer might acquire an interest. A protected buyer is also an individual who has attended an individual showing of the property or communicates with the agent of the firm or cooperating firm regarding any potential terms upon which the buyer might acquire an interest in the property, but only if the firm or its agents delivers the buyer's name to the seller in writing. And here, this is where it's important, no later than 3 days after the earlier of expiration or termination of the listing. The requirement is to deliver the buyer's names to the seller in writing may be fulfilled as follows. If the listing is effective only as to certain individuals who are identified in the listing by the identification of the individual in the listing, or if a buyer has requested that the buyer's identity remain confidential by delivery of a written notice identifying the firm or agents with whom the buyer negotiated and the date of the individual showing. So if you don't have that buyer's name, or that the buyer just does not want to release it, or the agent does not want to release the buyer's name, then you can identify the agent who showed it on the day that they showed it and at what time, if you have that, in lieu of the actual buyer's name.
And we have a templated letter that you can fill out with those names, and then you sign it, and then I sign it. A broker needs to sign that letter as well. And then that letter has to be mailed, postage, to the seller within 3 days of the end of that listing contract. If you put in the listing term that letter can be emailed, then you can email that exception letter. But otherwise, you must post it in the mail within 3 days of the end of the listing term. And that's pretty important because sometimes there are challenges to this, and you want to make sure that you do it correctly and that you have the correct information and that you did it, as Steph said, in the required timely period.
Is there an option for that on the contract, or does that need to be written in?
The option to email, you mean?
Yes.
It would need to be written in.
Okay,
It's not crash printed that way.
Yeah. Just find a place.
And even if, I think it's a good practice, even if it's not written into the additional provisions that it can be emailed, you're gonna mail it and still email it, just to cover your butt.
But to be enforced, it has to show that it was mailed
Yeah,
within 3 days.
yeah. So, and then you as the listing agent, the former listing agent, you know, you need to kind of keep on top of it. If you see that it closes, or if you see that it gets relisted and it closes, then you're gonna want to, you know, check the tax records and, you know, and just see who bought it if you have any doubt that it could have, if you have any suspicion that it could have sold to a protected buyer and you were cut out of it. So,
Hey, Steph, with that, if you notice that you are cut out of it, then can you still be paid the commission, or are you just kind of SOL at that point?
no, we would go to the firm that sold the property, and you know, Joni probably definitely has more experience with this, but we would ask for the firm's commission, or we might be going to the seller for commission.
Okay.
So depending on the situation. So
Okay, thanks.
yeah. Okay, so page 5. Now we're just getting into additional provisions of the listing contract. So just explaining to the seller now occupancy. So unless otherwise provided, seller agrees to give the buyer occupancy of the property at the time of closing. And then this is a good time to remind them, and you're going to remind them of this throughout the transaction, but that the property must be in broom swept condition and free of all debris and personal property, except for personal property belonging to any tenants, or anything sold to the buyer or left with the buyer's consent. So again, another point of contention at final walkthroughs. So you need to make it a part of your process to be continuously reminding sellers on how the property needs to be. So that's all debris in attics, garage rafters, basements. There's so many times when we get the rebuttal that, well, this was left here when I bought the house. Doesn't matter. It needs to be gone. So, and again, unless there's something that the buyer consented to leaving, then it's got to go. So, but yeah, on those final walkthroughs, if there's anything left behind, then the buyer's agent is going to get in touch with you and say X, Y, and Z needs to be gone before closing. So, leased property. So if property is currently leased and leases will extend beyond closing, the seller shall assign the seller's rights under the lease and transfer all security deposits and prepaid rents to the buyer at closing. So if you are listing a duplex, and there are tenants in there who have who their lease does not expire, it will likely not expire before closing, then those tenants leases have precedence over any other term in the offer to purchase. So those tenants will stay beyond the seller's closing, will stay beyond closing, and they get to I don't know why I'm muddling through this. They get to stay at the original lease term and date. So, and then again, those security deposits will just be credited to the buyer at closing. And then the buyer will take care of handling returning any security deposits once those tenants vacate. Any questions about that? Okay. Notice about the sex offender registry. This is in the listing contract, but I feel like this pertains more to a buyer who might want to know if there's a sex offender in the area before they buy a home. But if anyone has questions about the sex offender registry, they can consult this website or call that phone number. real estate condition report. So this is seller's provision, a provision for the seller, letting them know that they agree to complete the real estate condition report provided by the firm to the best of the seller's knowledge. Seller agrees to amend the report should seller learn of any defects after the completion of the original real estate condition report. But before acceptance of a buyer's offer, the seller authorizes the firm and its agents to distribute the report to all interested parties and agents inquiring about the property. And seller acknowledges that the firm and its agents have a duty to disclose all material adverse effects required by law.
Yeah, and it's a reminder, I just answered a question on my text message with another agent who's buying a for sale by owner. And she wanted to know if the for sale by owner seller has to fill out a condition report. This is not a real estate law. This is a Wisconsin state law. So all parties selling homes, whether they're for sale by owners or listing, must fill out a property condition report, except for the exceptions that are noted.
Yes, and there's a big old warning here for the seller. Well, seller represents the firm that as of the date of this listing, seller has no notice or knowledge of any defects affecting the property other than those that they listed in the record in the real estate condition report. And then if seller representations are incorrect or incomplete, seller may be liable for damages and costs. So this is the biggest reason for post-close litigation. If a seller is just not disclosing something that they know about the home, or incomplete with their disclosure. So, maybe giving a half truth about the condition of something. So,
Yeah, I would like to bring that up too, because we're currently on the verge of a lawsuit, because the listing agent didn't enforce the idea that the real estate condition report wasn't completely filled out. The seller skipped about 4 items, just no marks whatsoever. And the buyer is now potentially suing the seller and maybe suing the real estate firms. And the issue that's come up is the fact that it was an incompletely filled out. Excuse me. It was an incompletely filled out real estate condition report. So as the listing agent, make sure that when the seller fills that out, you have no participation in it at all. You can't help them fill out anything, and that you just review it to make sure they have filled out every item.
yeah. Very important, you guys.
Yeah.
Yeah, let's a big part of our job is getting to closing, but then also preventing post-closing issues. So there's nothing worse than getting dragged into something after closing. So seller cooperation with marketing efforts. So seller agrees to cooperate with the firm in the firm's marketing efforts and to provide the firm with all records, documents, and other material in seller's possession or control, which are required in connection with the sale. Seller authorizes the firm and its agents to do those acts reasonably necessary to effect the sale, and seller agrees to cooperate fully with these efforts, which may include a use of a MLS, internet advertising, lockbox system. Seller shall promptly refer all persons making inquiries. This is important. Seller shall promptly refer all persons making inquiries concerning the property to the firm and notify the firm in writing of any potential buyers with whom the seller negotiates or who view the property with seller during the term of this listing. So just a reminder to the seller, even if this is an exclusive right to sell listing contract. So if you as the seller entertain a buyer's questions or begin negotiations with a potential buyer, you need to refer them to us. We would still be owed a commission. Open house and showing responsibilities. So hold harmless agreement here. Seller is aware that there's a potential risk of injury, damage, and or theft. Excuse me, my have had some allergy attacks as of late. So if I start sneezing, excuse me, I feel one coming on. Seller accepts, seller is aware that there is a potential risk of injury, damage, and or theft involving persons attending an individual showing or at an open house. Seller accepts responsibility for preparing the property to minimize the likelihood of injury, damage, and or loss of personal property. Seller agrees to hold the firm and its agents harmless for any losses or liability resulting from personal injury, property damage, or theft occurring during an individual showing or open house other than those caused by the negligence or intentional wrongdoing of the firm and its agents. So this actually just came up. We had one of our agents hold an open house. When they locked up, they did not close the patio door completely, and it blew open during a crazy windstorm. Water got in. Property was like half occupied, and that the seller spent time down south. They were down south for a few months during this. Water got in. That was negligence on the part of our agent, and they were responsible for paying for fixing the wood floor that got damaged. So just a reminder to you guys, make sure you're being vigilant about checking doors and that the property was in the same condition as it was when you got there for either for a showing or for an open house. Seller acknowledges that individual showings and open houses may be conducted by licensees other than the agents of the firm. So that's a good reminder too, to let agents know that, you know, if we're holding open houses for you, it might be me, but it might be another colleague of mine. Appraisers and inspectors may conduct appraisals and it's may conduct appraisals and inspections without being accompanied by agents of the firm or other licensees, and that buyers or licensees may be present at all inspections and testing and may photograph or videotape property unless otherwise provided for additional provisions. So if your seller does not want their home to be additionally photographed or videotaped, then you would put that in additional provisions, and then we would communicate that through MLS private remarks. Termination of listing. Neither the seller nor the firm has the legal right to unilaterally terminate this listing, absent a material breach of contract. Seller understands that the parties to the listing are the seller and the firm. Agents for the firm do not have the authority to enter into a mutual agreement to terminate the listing. So again, you are filling out this listing contract, but the listing contract is between the firm of Keller Williams and the seller, not you as the agent. If there are any, you know, we're not in the business typically of holding people in contracts they don't want to be in. So, you know, just talk to one of us if you have an agent who wants to, or if you have a seller who wants to get out of a listing contract. And we, as the brokers, need to sign those expiration dates or expirations. Earnest money. The firm holds trust funds in connection with the transaction. They shall be retained by the firm in the firm trust account. The firm may refuse to hold earnest money or other trust funds. Should the firm hold the earnest money, the firm shall hold and disperse earnest money in accordance with Wisconsin Wisconsin Statute Chapter 452. The transaction fails to close and the seller requests and receive the earnest money as the total liquidated damages. Then upon the disbursement to seller, the earnest money shall be paid first to reimburse the firm for cash advances made by the firm on behalf of the seller and one half of the balance. I'm not going to go through the rest of that. I use this to let agents know or let sellers know that earnest money will be involved as part of the offer to purchase. It's held in our trust account. It does not go directly to you. A lot of sellers have had that question and have thought that they keep the earnest money, but it all goes towards the down payment of the purchase. And I also let them know if there's a breach of contract by the buyer, then they could potentially receive that earnest money. But we'll get to that we'll cross that bridge if we come to it. And then the last page is just the delivery of documents and written notices. So this formalizes how documents are to be delivered. So you have a few options here. We've got personal delivery, fax, commercial delivery, US mail, or email. Personal delivery is automatic. So you would want to put in the seller's name here on line 285. 286 is where you'll put your own name. I do not advise putting fax, commercial delivery, or US mail as an authorized form. I don't know the last time I saw that, but typically it's personal delivery or email. If it's email, then 9.9 times out of 10, you're going to put the seller's email address there and then your email address for the firm. Any attached addenda, you could put the KW disclosure here. And otherwise, like the real estate condition report or addendum S that will be attached to the offer. Line 311 through 312, you're going to name the term of the contract. They are typically 6-month contracts. You can tighten that. You can make it longer if you want, but that's what's typical is 6 months. Seller will sign on 317 or 319. If it's a seller entity, let's say it's an LLC, or if it's a trust, you would name that on line 325, and then the authorized signature of that seller entity will sign on line 327. You will write your firm. You'll write your name here. Your brokerage. And then you will sign on line 329. And now you've got an executed listing contract.
I want to bring up one point for the term of the listing on the last page. Sometimes there's been a problem on when the listing started, the day of the listing, when it has to be turned into MLS, which is 48 hours from the date of the listing. All of that term of the listing is on line 311 and 312. It has nothing to do with the dates of the signatures of the sellers on lines 317 to 312. And a lot of times an agent will confuse these dates under the signatures as the date of the listing. MLS, attorneys, brokers, agents, all will reflect the day of the listing starts on line 311 and it terminates on line 312. So all of your counting and everything like that goes from the term of the listing first date. So.
Thank you for pointing that out. Yeah. We've also had, and if you're doing a delayed listing, for example,
Yes,
you're still operating off of this term, the start term on line 311.
and that's the day that it has to go into MLS in 48 hours.
Okay, I was going to ask that. Thank you.
Whew. All right, you guys, any questions? Thank you for being here with us.
Thank you for having the training.
Yeah.
Appreciate it. Thank you.
Yeah. All right. We'll see you guys soon. Thank you.
All right.
Bye.
Thank you.
Yeah.
Bye.